Hello, my name is Joseph Hewitt, and I'm an associate on the Employment, Pensions and Incentives team at William Fry. Today I will be discussing the steps employers in Ireland should take when you receive a protected disclosure. The Protected Disclosures Act 2014 was amended in 2022 with the objective of protecting workers from retaliation who report relevant wrongdoings which they reasonably believe have arisen in the workplace. For the purposes of the legislation, the definition of a relevant wrongdoing is very broad and encompasses criminal offences, health and safety risks, miscarriages of justice, damage to the environment, and misuse of public funds. The legislation requires certain employers to establish and maintain internal reporting channels and procedures for receiving, acknowledging, and investigating reports in a secure and confidential manner. These employers must also select a designated impartial person who will follow up with the worker who made the protected disclosure. The employers currently obliged by the legislation are private sector employers with 50 or more employees, public bodies, and employers who operate in certain regulated industries, including the financial services sector. So, what should an employer do when they receive a report of a protected disclosure through their internal reporting channels? First, they must acknowledge the report in writing within 7 days of receiving it. Second, they will need to arrange for the designated person to carry out an initial assessment of the report. This generally involves seeking further information from the reporting person and any relevant third parties to establish if there is a prima facie evidence of a relevant wrongdoing. If, after having carried out this assessment, the designated person concludes that there is no prima facie evidence of a relevant wrongdoing, they can close out the matter and communicate this to the reporting person. This may include redirecting the person to the company's internal grievance procedures as a more appropriate forum for them to address their concerns. Where the designated person concludes that there is prima facie evidence that a relevant wrongdoing may have occurred, the designated person must take appropriate action to address the alleged wrongdoing and update the reporting person of that action taken within 3 months of receipt of their report. While the appropriate action will vary in each instance, it can involve referring the matter to investigation and thereafter taking steps to rectify a breach or to prevent its recurrence. Failure to establish internal reporting channels and procedures is a criminal offence, which could, in theory, result in a fine of up to €250,000 and/or imprisonment of relevant officers of the company for a period of 2 years. As such, we recommend that all employers, and especially those who fall within the obligations of the legislation, first, put internal reporting channels and procedures in place. Second, train your managers to identify a potential protected disclosure so that they can respond accordingly without delay. Third, review your procedures regularly to ensure that they are effective. And finally, clearly signpost the reporting procedures to encourage workers to raise their concerns through those channels so you are on notice that the worker has made a protected disclosure. Please reach out to your usual contact in the William Fry Employment, Pensions and Incentives team if you have any queries in relation to protected disclosures. Thank you very much.